I, Ganalok Mohanty, General Secretary, Adhivakta Parishad Odisha, welcome you all in the webinar to commemorate 159th birth anniversary of Swami Vivekananda. And this web series is dedicated in the name of late Baburao Paldhikar, who was a legendary figure and the founder of Rashtriya Swayamsevak Sangha in the state of Odisha. In this webinar, we have taken a topic hello again. In the webinar, we have taken a topic constitutional history of Indian Republic and the idea of transformative constitution. We are very much fortunate that today we have got our chief guest and keynote speaker of this function, Justice Sashikanta Mishra, presently Honorable Judge of Orissa High Court. We, on behalf of Adhivakta Parishad, very much obliged before your Lordship that he has given his kind consent to grace this occasion as chief guest and keynote speaker. I, on behalf of Adhivakta Parishad Odisha, welcome you, sir. Today, we are having another guest to this function, Shri Rudra Prasad Kara. He is a renowned lawyer of our High Court. He has almost practiced 35 years in the Honorable High Court of Orissa. He has practiced in different branches of law. Today, we are very much fortunate that he will be acting as a moderator in this function. We are also having with us our President, Shri Kambupani Padhi. He is presently President of Adhivakta Parishad Odisha, and also he is the Zonal Secretary of Akhila Bharatiya Adhivakta Parishad. Under him, 3 states. He is looking after the affairs of Adhivakta Parishad in 3 states: Odisha, Bengal, and Andaman Nicobar Island. I, on behalf of Adhivakta Parishad, welcome you, sir. Now, without wasting any time, I would like to invite our moderator of this function, Sri Rudra Prasad Kara, to deliver his speech on the topic Constitutional History of Indian Republic and the idea of transformative constitution as a moderator. Over to you, sir. Rudra, sir.
Thank you, Gyano Babu. To talk understand, appreciate the growth of this nation, various national affairs. The topic of discussion is one of the leading constitutional history of India and idea of transformative and as a part of Sri Baburao G. Paldhikar's Memorial Lecture Series. Now, friends, as you are all aware, nationalism, equality, mass education, secularism, eradication of casteism, women empowerment, and many similar ones were deliberated in the Constituent Assembly, enshrined in the preamble and fundamental rights chapter of our Constitution, and in our goals of a welfare state as discussed in the Directive Principles chapter. Now, these are the thoughts which are also the transformative promises of the Constitution of India. The Indian Constitution, being a dynamic one, changed and transformed in order to meet the aspirations of its citizens and to help them march ahead with time, helping the concepts like fundamental rights and socio-economic and political justice, ensuring equality of status and opportunity to all sections of the society as its central goal. Now, while debating on the idea of transformative constitution, one must not forget that India, that is Bharat, predates the constitution. Its cultural nationalism makes us Indians in the true sense of the term. Our rich heritage of cultural liberalism, pluralism, and tolerance is subsumed in our constitutional history, and future transformative changes in the Constitution can liberally draw from these repertoire of our cultural heritage and also reflect the vision of the thinkers and lead us to the path of a glorious future of all Indians. Now, the question arises that who bears the onus of ensuring that this transformational change takes, is taken to its logical end? Is it the courtrooms, or the parliament, or the government departments alone who are vested with the responsibility of ensuring this transformative changes as per the constitutional goals? In my humble opinion, it is we, the citizens of the country, who have given ourselves the Constitution, who bear the onus of not having a fractured society filled with hatred, mistrust, and bias, and then only the constitutional goal can be fulfilled and the transformation of the Constitution to meet the ends and the promises made in the Constitution can be fulfilled. We are indeed privileged to have with us a man of many parts who is none other than Honorable Justice Sashikanta Mishra, Judge, Odisha High Court, as our chief guest and keynote speaker of the evening, and he would be throwing much light on the topic of this webinar. And it will now be my responsibility and privilege to request him to please share his thoughts on the topic. Over to you, Justice Mishra, please.
Thank you, sir. First of all, I must congratulate the Adhivakta Parishad for organizing this webinar. Not only this webinar, but I'm told that they're doing it on, you're doing it on regular basis, which I'm sure will definitely help in broadening the mental horizon of the lawyers, particularly the younger lawyers. I believe, I'm an old school person. I believe in the adage that knowledge is power. So, to be a successful lawyer, to acquire the skills of advocacy, court craft, and all that, the foundation is knowledge. So that way, as I said, even though I might sound a little bit old-fashioned at the beginning, it is knowledge alone that would ensure a truly, qualitative as well as, efficient career, a competent career as a lawyer. So thank you for that. And respected the President, Mr. Kambupani Padhi, General Secretary, Mr. Gyanalok Mahanti, Moderator, Shri Koro, And as I was just briefly interacting, senior Shri Bimbisar Das and other members, and all those who are connected virtually to this webinar. Very good evening to all. Now, the topic is quite long, and on first brush, it appears as if there are two topics merged into one. Now, the constitutional history of Republic India, this is one part, and the idea of transformative constitution, this is another part. As I said, on the first look, it appeared as if there are two topics. I was a bit worried. I mean, how to speak on two different topics, one particular occasion. But then I pondered deeply over it. I delved deep into it, and to my surprise, I found that actually it's just the same. I mean, the whole idea behind selecting this topic is the same. To put it very simply, through this topic, we would like to prove or establish how the Constitution has proved itself to be a transformative tool. Now, transformation, how it has done so, we will be discussing over the next maybe half an hour. Now, this selection of the topic is very important. You see, when we discuss cases, we discuss a particular case law, the ramifications thereof. There may be limitations because they are a particular case law, supposing a decision relating to a particular section of the CRPC. It has limited ramifications. It will affect a limited section of the society. But when you touch the Constitution, you affect the entire country. Now, what is the Constitution? Constitution, as very beautifully put by Sri Karo. Now, the country predates the Constitution. This is a country, we are talking of a country which has a history, civilization spanning maybe 5,000 years back. So, and he also added that the cultural ethos, all that is known as the Indian civilization, was subsumed in the Constitution. If you turn the pages, if you read between the lines, you will find the echoes of the same philosophy, the same, the cultural ethos, the spiritual values, speaking through the words of the articles and of the clauses of the Constitution. So, again, I must congratulate you for selecting me the topic, but at the same time, I must hasten to add that whether I will be able to live up to this Herculean task or not is for you to decide. I don't know. But then, when I anything relating to the Constitution is incomplete without reference to the preamble, as Sri Kora has very rightly pointed out. The preamble, it contains, it's the doorway. Let us say it is the door. It is the path through which you enter into the whole body called Constitution. If you have understood the preamble, then you have a better chance of understanding the different clauses, different articles of the Constitution, different provisions. Because everything has to be measured on the touchstone of the preamble. It contains the soul, so to speak, of the Constitution. Now, talking of the preamble, let me, as you all know, very recently, on the last November 26th, the Constitution Day, the preamble was a plaque containing the preamble, with the preamble written on it, was affixed here in the High Court. Not only in the High Court, but all over the state, in all courtrooms. And even prior to that, when I was also a district judge, I was asked by the High Court to ensure that a copy of the preamble is fixed in every courtroom. And we did it. Not only me, all the district judges did it. Now, this is with the purpose, sir. This is according to me, if I have the preamble hanging in the wall opposite me, or even behind me, I'm reminded. Every time I ride on the dais, I'm reminded that I'm doing a constitutional duty, sir. This public service is just a pious constitutional duty. So with these opening words, let us now begin. Now, the history of the constitutional history of the Indian Republic. Now, this much, let us first segregate it. Then we'll see whether we can make it a unified whole. Now, this history, what we are talking about, is the history of the Indian Republic. So, the Republic, India became a republic in 1950. So, obviously, it means the Constitution, the history of the Constitution over the past 72 years. Now, friends, one criticism that is usually aimed at our Constitution is that it has undergone multiple amendments. So much so that some quarters, some persons believe that the original document is lost. That probably the original document is no longer there. Now, as compared to a country like United States of America, and as you all know, we have also borrowed from some ideas from the American Constitution. Now, that was framed more than 200 years ago. And till date, it has undergone, I'm told, only 27 amendments. But we in India, in the last 72 years, we have amended our Constitution more than 100 times. It raises some very, very important questions. Was the original document wrong? Or was there some ambiguity? Were the framers of the Constitution lacking in intelligence? Well, obviously, the answer can be no to all these questions. I mean, our Constitution, apart from taking the salient features, the good points, rather, the positive aspects of different constitutions, has also retained the basic values this country, this civilization has always stood for: the plurality, the tolerance, the secular character, all these things. The question of an egalitarian society. I cannot restrain myself from quoting this mantra: Swasti prajabhyo paripalayantam nyayena margena mahim mahisha go brahmanebhyo shubhamastu nityam loka samasta sukhino bhavantu. Now, today also, when you call a priest to perform some puja, at the end he recites this mantra, which is a Shanti mantra. But if you read Swasti prajabhyo paripalayantam, now blessings are given to a place, to a country, to the king of that country, to the sovereign, the ruler. Swasti prajabhyo paripalanam. Praja paripalan means ruling over the subjects. Nyayena margena mahim mahisha. How does he rule? By following the principles, the principles of justice. Nyayena margena, the path of justice. Go brahmanebhyo shubhamastu nityam. Go means, you can say, material resources. Brahmana means intellectual resources. Where these intellectual and material resources are protected, loka samasta sukhino bhavantu. Maximum good for the maximum people, maximum welfare for the maximum people. Now, Sri Kora has referred to the welfare state. These ideas are borrowed from, this is a small mantra. You just turn the pages of any old Shastra, Vedanta, the Upanishads, the Vedic knowledge. You will find a Vedic text. You will find these very ideas. So on the foundation of such a foundation, this Constitution has been built. And the framers of the Constitution, they were men of sterling character. We need not dwell upon it. We know, headed by no less than Dr. B.R. Ambedkar, one of the finest legal minds of the country. They took more than 2 years to draft this constitution. Each and every article, each and every clause was hotly debated. Now, so to suggest that it was an arbitrary document probably will not be an acceptable argument. So, how do you explain this multiple amendments? Now, here I will briefly digress to the transformative part, because here, in its role of transforming the society as envisaged in the Constitution, it requires amendment. Because we as Indians, we the people of India, we recognize or we acknowledge a very fundamental fact that life is not static. Life changes, it's dynamic. Every moment it changes. What was true yesterday may not be true today. The whole perception changes. Imagine when we were young, all of us probably, we had no access to internet, we had no access to mobile phones, we had no access to any kind of gadgets. But compare the children of today. So the perception changes. And this acknowledgement gives us the thought that yes, there is a need to change. It's not that what we are changing is bad. What we are changing is actually that which is required for now. What was there is no longer required. So that is the basis of change. So this is how I would like to explain the multiple amendments and to meet the so-called criticism that the Indian Constitution has undergone so many amendments, so probably the original document was not very properly drafted and so on and so forth. Now, and another word I would like to say is let us think of India as it stood on the eve of independence or on the eve of becoming a republic. Let us talk of 1940s, pre-1947 India. What was India, sir? India was, had more than 500 princely states, politically all independent. A part of the country was ruled directly by British. The other part, and a substantial part, was not so directly ruled, but indirectly ruled. So we had, several Indias. But socially, culturally, there was unity. Political unity was not there. So this is kind of a, country was handed to us by the British when they left. And you all know how, the government of the day took pains to unify the entire the country, which was fragmented. But this was the time when we needed a document, we needed a constitution to bind us together. As is oft quoted, the Indian Constitution is unitary in spirit and federal in character. So when we as children, we were taught unity in diversity, this is the same concept we were referring to. So the India that we had at that point of time, we must imagine when the Constitution was written. And in this fast changing world, one wise man once told me, son, I have seen in the last 50 years a change of more than 500 years. And you will all agree with me, in this fast changing world, it would probably not be proper to hold on to that kind of situation as was existing at the time of independence, and to say that no, since it was there in the Constitution at that point of time, it must be correct and we must follow it. So when we talk of history of the Constitution, as it has panned out in the last 72 years, we must keep it in mind that when we inherited, it was a country, it was in a sort of a flux. Nothing was, clear. But the Constitution was the first attempt at, unifying and in bringing in a cohesion. So it is, as it is always said, it's the mother of all laws. It is the organic document, the organic law of the country, rather. So in its history, when we talk of its history, there are two ways of looking at it, as I see it. So you just say on which date which amendment took place, what was the amendment, what was the effect of that amendment, rather. This is one way of looking at the history. The other way, and which I feel probably is appeals to me personally, the history of the Indian Constitution is nothing but the history of how Article 21 has been interpreted. Because according to me, the very soul of Indian Constitution is Article 21. So let us try to analyze how Article 21 has been interpreted. I have before that I will briefly refer to the Keshavananda Bharati's case. As you all know, I need not dwell upon it in detail. But AR 1973 Supreme Court 1461. Yes. So just for a brief moment, I will say, because that is a very, the most significant judgment insofar as constitutional history is concerned. 13 judge bench. What happened is that, as you know, in earlier, prior to Keshavananda Bharati, it was held that the amendments to the constitution cannot be reviewed by courts. Now in Golaknath, it was held, IC Golaknath versus State of Punjab. It was held that the courts could review amendments to the constitution as they fell within the purview of law, within the meaning of Article 13(2), if they violated any fundamental rights. Now, Parliament sought to nullify the judgment in Golaknath's case by inserting Article 13(4), Clause 4 to Article 13, by saying that, if I may read for a moment, it says, it referred to Article 368, the power to amend the Constitution. It simply says, nothing in this article shall apply to any amendment of this Constitution made under Article 368. So back to square one. So in this background, Keshavananda Bharati came. Now Keshavananda Bharati said, yes, all the constitutional amendments that were sought to be challenged, the 24th, 25th, and 29th amendments relating to land reforms and all that, the Supreme Court held, yes, although Parliament has the power to amend any part of the Constitution, but it added a rider. It cannot use this power to alter or destroy the basic structure or framework of the Constitution. This is very, very important. One of the most significant, and why it is the most significant judgment according to me. And in fact, in the words of Professor Upendra Bakshi, Keshavananda is the Indian Constitution of future. He has gone on to say that. How very prophetic these words are. We are still relying upon the basic structured doctrine or basic features, whatever you call it. Now that was again expanded a little bit in Minerva Mill's case to say that judicial review, along with that limited amending power, limited why? Now you cannot touch the basic structure. So judicial review and limited amending power are also basic features of the Constitution. So what happened? Now Supreme Court became the final arbiter in matters concerning interpretation of the Constitution. So I was talking of Article 21. Before going to the case laws, some of the case laws, that is why I wanted to bring in this Keshavananda Bharati's case, because the position of the Supreme Court as the final undisputed arbiter of the interpretation of the Constitution, of the custodian of the Constitution, if I may say so, was left no longer in doubt. Now, I will, as they say, the proof of the pudding lies in its eating. So if I talk about history, how the Supreme Court has interpreted Article 21, all of you know, quite a lot of cases are there. I have picked up only 4 cases. only 4 cases because of the constraint of time. So I will briefly touch upon those cases, and all of you must be aware of it. Not that I'm adding anything to your knowledge, I'm just sharing with you. The first case that comes to my mind is Maneka Gandhi. Year 1978 Supreme Court 597. Now the case was simple. Her Mrs. Maneka Gandhi's passport was impounded, and her right to visit a foreign country was abrogated, and all that. But the Supreme Court, went beyond its brief, and for a justified reason. It was held that earlier it used to be held that the fundamental rights guaranteed under the Part 3 of the Constitution, they are all distinct. Each has to be taken as its own, and each has to be read in its isolation. Supreme Court changed the perception in Maneka Gandhi. It said, no, all the fundamental rights are to be read as a whole, as a integrated scheme. That is one part. Second part, it said, interpreting Article 21. What does Article 21 say? No person shall be deprived of his life or liberty except according to procedure established by law. Now the question that we pose, what if the law is unfair? We say that the procedure according to law. Tomorrow we frame an arbitrary law, discriminatory law, and say that this person is not entitled to because of this law. It's very easy to say that for the parliament or for the executive. So, no. That is why the Supreme Court went a step ahead by saying that no person shall be deprived of his life or liberty. Yes, except according to fair, just, and reasonable procedure established by law. So these words were read into Article 21. They're not there in Article 21. Today also there is not there. But when we talk of Article 21, we read also these 3 words, that fair, just, and reasonable procedure. You cannot just come out with an arbitrary law. And Supreme Court said, an arbitrary law is no law. Very strong words indeed. That is why I have started with Maneka Gandhi. And second decision that I would refer to is Olga Tellis. Olga Tellis, the case of pavement dwellers in Bombay. They were sought to be evicted by there was a huge eviction drive carried out by Bombay Municipal Corporation, and they were sought to be evicted. Admittedly, they were squatters. They had no rights. They had encroached upon the pavements. They were living there. If you read that judgment, there's a particular paragraph. Of course, right now I don't have. I will request all of you, particularly the younger friends, please read that paragraph where the Supreme Court explains the life of a slum dweller in Bombay. Beautifully written. Almost a piece of literature. Now, here for the first time, in Maneka Gandhi, we have seen how Article 21 was interpreted. Now, in Olga Tellis, what happened? Supreme Court said that, what is the meaning of right to life? If that person lives without having any means to earn a livelihood. So, there it was held that right to life includes the right to livelihood. Now, as the legal scholars always like to say, that the Supreme Court made a distinction between the primary, not a distinction actually, referred to the primary, first generation rights or the primary rights and the second generation rights. This second generation right is what is known as the right to livelihood, which is embedded in the right to life. It was again read into Article 21. Then the third decision, which fortunately or unfortunately relates to Odisha, Nilapati Behra. Before that, Nilapati Behra, which is Air 1993 Supreme Court 1960. 93 Supreme Court 1960. Now, prior to Nilapati Behra, this is a case of custodial death, as you know. And let me remind you, I was told by somebody in the Judicial Academy, the professor also told us that Nilavati Behera along with Nandini Satpathy versus PL Dani are cited in other countries, including the UK and USA. So what happened? All of you must have heard about the Bhagalpur blinding case, where in Bihar, certain convicts, certain accused, some accused persons, they were blinded by pouring acid on their eyes. Now they approached the Supreme Court. Supreme Court came down very heavily on the state administration, directed action to be taken against them, but stopped short of paying any compensation, monetary compensation. Then there was another case, Rudul Shah. I just don't have the citation, but Rudul Shah I can share with you later on through Tirtha. So he continued to languish in jail for 14 years, even after he was dead. For the first time, awarded 30,000 as compensation. Then thereafter, on and off, in some cases 10,000, in some cases 20,000. Then came Nilavati Behera. What happened in Nilavati Behera? Nilavati Behera is a woman who wrote a letter to the Chief Justice of India, stating her anguish, putting forth her grievance that her son, a young man called Suman Behera, who was accused of theft, was picked up by the police, taken to custody, mercilessly beaten, and on the next day is found thrown near a railway track. Near a railway track with severe, body injuries. The strange thing about it is that the state took a complete the case of Shri. He was run over by the train. Of course, we couldn't accept it. Then 1 lakh compensation was. Well, the amount is not important. What is important is first is prior to that, when if you wanted compensation, then you have to approach this common law forum. Now, in a public law remedy, like the High Court, when you are approaching the High Court in 226 or the Supreme Court in Article 32, ordinarily no compensation is payable. There, the Supreme Court for the first time made a distinction that yes, compensation can be paid even in a public law proceeding if there is a violation of fundamental rights. And in this case, there was serious violation of fundamental rights. Article 21, serious violation. You cannot just pick up a person at your own sweet will, and you cannot just deal with him like an animal and then throw his dead body. And as I will again request, there's the same Jai Bhim decision. Justice Chandru, when he was a lawyer, how he had, all of you must have seen it. If anybody has not seen it, please see it. Beautiful film. Again, custodial death. Then the final case that I would refer to in this regard is Aruna Shanbag's case. 2011, 1, scale 673. What is Aruna Shanbag's case? You all know. A nurse working in a hospital, in a very famous hospital of Bombay, was strangulated, raped, not raped exactly, sodomized, and left to die. Now, because of lack of oxygen to her brain for a pretty long period, she was paralyzed. She in fact went to a vegetative state, a state of permanent coma. She continued for years together. Now, an application was filed before the Supreme Court, initially before the Bombay High Court, then Supreme Court, seeking permission to die, which we call euthanasia. In some countries, it is permitted. In some countries, in different forms, it is permitted. Now, the Supreme Court considered whether this will amount to committing suicide. What the Supreme Court said, very interesting. Right to life. Earlier, as you know, that decision, Justice Hansaria's decision, which was subsequently overruled. In that case, it was held that right to life includes right to die. All right. Now, Supreme Court said, yes, right to life includes the right to die with dignity. But right to die per se cannot be included in Article 20. This is the reason why I talk of this decision. What happened in that case is not very, that is besides the point. Supreme Court said, holding such, Supreme Court said, allowed in fact passive euthanasia. Now, there are two things, in so far as euthanasia is concerned. Either you ask for a lethal injection, which is a positive act, or you withdraw all treatment, which is a omission. Supreme Court said that yes, this is permissible under certain circumstances. Certain guidelines have been laid out. Now I have referred to all these 4 decisions. As you have seen, initially I refer to that for background purposes. I refer to Keshavananda Bharati for that basic structure doctrine. Now we refer to only 4 decisions concerning Article 21. There are hundreds of decisions, many important decisions. I felt that these 4, they have, they have charted the course of the Constitution over the last 72 years as no other decision has. These are very, very important because they touch certain very fundamental aspects of life. Now, moving on, the idea of, we come to the second point, the idea of transformative constitution. We have already seen how the constitution is capable of influencing the daily lives of human beings, daily lives of the citizens, daily lives of all persons, because there are some fundamental, like Article 14, Article 19, Article 21. They do not refer only to citizens. They said no person or all persons. So anybody, a Bangladeshi national, when present in India, will also be entitled to those benefits. Now, we often ask, and somebody very, not in the recent past, but quite some time ago, an academician who understands little law, he once told me that you see, every this country is going in a very wrong direction because of the constitution. I was surprised. I said, why? There are so many articles and so many, you have more than 500 articles. There is so many laws, that is why it's causing all the problem. And what is there if you just keep on making laws? I did not answer him. Whatever I answered is again besides the point. But it left me thinking: is really the Constitution of India a dead letter? No, as I said in the beginning, and Mr. Kaura has referred, it's a dynamic document. It's a living entity, sir. It very much affects our life, day-to-day life. We have seen. Right from Maneka Gandhi, Olga Tellis, Nilapati Behra, Aruna Shanbag, and the list just goes on. But for the intervention of the Constitution, just imagine what would have happened. That is why, even today, the last recourse for the people of India is the judiciary. Now, it cannot be treated as a dead letter. When again, as I look back at the period when we became independent, what did we inherit from the British? We inherited a society, as Mr. Kaura had pointed out, a fractured society, a society with gross inequalities on the social level, cultural level, economic level, gross inequalities, divisive trends, gender injustice, and whatnot. Now, to decide or to see whether the Constitution has been a transformative document is to test it against these points, how it has impacted the life of the citizens in these aspects. Has it been a harbinger of social change? Has it been helpful in reducing the social inequalities, gender justice, gender inequality? We will examine it, of course, but I will refer to a book by the celebrated author, late Granville Austin. Again, all lawyers must read it, and particularly the younger lawyers, you must read, because he is an American. He was an American scholar. He's a person who looked at the Indian Constitution very closely, but he's an outsider, so you get a better perception, a neutral perception. He says that Indian Constitution has worked, while many people say that it hasn't worked. He says that it has worked, but let us not take his words on their face value. Let us test for ourselves whether it has worked or not. I was referring to the society which was divided on socio-economic terms, social inequalities. Again, I'll tell you, you just pick up a book by Gopinath Mahanti, Hoijam. It has also been translated in English. It is about the scavengers of Cuttack, the kind of life they led, and the social and cultural discrimination that they faced just because they were born in a particular caste. So I will not get into those things, but then let us examine. Here also I have referred to some decisions, because as I said, the proof of the pudding lies in its eating. So I have referred to only 3 aspects because of the constraint of time. We cannot enlarge it. To see whether the Constitution has really been a transformative mechanism. Has it really ushered in an equitable society as promised in the preamble? Again, just Mr. Kaur was referring to justice, social, economic, and political. Has it really been able to do that? Let us see. Let us. In these decisions, I have I thought of many things, but I again had a feeling that it will go on and on. So I limited it to only 3 aspects. One is reservation, the issue of reservation. The other is gender justice, and the other is again gender equality. Now, social inequality. I will first touch upon the vexed question of reservations. There have been several decisions, right? The Constitution, first amendment to the Constitution was also on the basis of a notification issued by the government of Tamil Nadu making certain reservations. That was challenged and all that. I will straight away come to Indra Swami. 1993 Supreme Court 477. Now, Indra Swami was there. Indra Swami was a journalist who challenged the recommendations of the Mandal Commission, which wanted 27% of the posts to be reserved for the other backward classes. Now, the Supreme Court held. Now, many arguments were laid before the Supreme Court. It's a beautiful judgment. One must read that judgment to know what was presented before the Supreme Court from both sides, or rather from multiple sides. It was not just an adversarial litigation. The Supreme Court said, those who form the creamy layer of OBCs, the concept of creamy layer was introduced. A person who has already received the benefit of reservation, his children are not entitled to reservation again. And third thing, Mandal Commission also had recommended that there must be reservation for economically weaker sections, even from other classes. Well, it sounds good, but Supreme Court said no, there is no provision in the Constitution to do so. You cannot do it. What is important is the creamy layer concept, which in fact is still holds good. Despite many things that have happened, much water has flown down the bridge since 1993, but the concept, the principle still exists. What Parliament did to nullify Indra Swami, it inserted Article 16(4) capital A. And because I'm sorry, I forgot. that the Indra Swami said that in promotions you cannot have reservations. Now, to nullify it, Parliament brings in Article 16(4) capital A. Then we come to Nagaraj versus Union of India. Now, where the validity of this constitutional amendment providing for reservations even in matters of promotion was challenged. Now, the Supreme Court upheld the validity of the amendment, but also held that the state is required to prove with quantifiable data the backwardness of the class benefiting from the reservation, its inadequacy in the position or the service for which reservation is claimed or promotion is claimed, and to show how reservations and promotions would further administrative efficiency. Why so? If you are interested to give this man promotion, you must show how by promoting him you will be furthering administrative efficiency. Now, again, moving on to Jarnail Singh, which was in 2000, which is probably a very recent judgment. I'm just forgetting. I have not noted down the citation. I'm sorry for that. In Jarnail Singh versus Lakshmi Narayan Gupta, it was said that in Nagaraj case, the insistence on collection of quantifiable data on backwardness in relation to SC and ST was contrary to Indra Swami and therefore bad in law. But they said that you have to prove, the state has to prove that this particular community has not been adequately represented in the promotional card. And on submission of proof, it will be allowed. Significantly, the Supreme Court also upheld, or rather approved, the creamy layer concept in the Indra Swami. Now, why I have referred to these decisions? Of course, there are two other decisions, Pavitra, BK Pavitra 1 and BK Pavitra 2, relating to an amendment brought by Karnataka government, which was in BK Pavitra 1, it was constitutionally, it was held ultra vires the constitution, because it had not collected the quantifiable data. But the government went back, formed a commission, collected the data, then again amended it. That was challenged. There the Supreme Court said, well, this part of adequacy or inadequacy of representation of a particular community is left to the subjective satisfaction of the state. Supreme Court cannot sit an appeal, or the courts cannot rather sit an appeal over it. So, why I have referred to all these decisions? They may appear to be, on the first look, relating to service jurisprudence. But you know, the very basis of all these decisions is to acknowledge the fact that social inequalities remain even after 72 years in this country. And the Constitution envisages an equitable society. Therefore, necessary steps must be taken. It is known as affirmative action. That is why it's known as affirmative action. Necessary steps must be taken. In all these judgments, you will find the principle is echoed in every single judgment, of whichever I have referred, and there are many other decisions referring to all these. These are important, 4 decisions, but referring to these decisions, there are many other decisions. We are running short of time, so I will just quickly conclude. Now, this, you see, impacts the majority of the population. This has transformed the lives of so many people. But for these decisions, it could have been either way. Now, the 50% limit left to government, you know, government may, for reasons best known to it, may expand the limit of reservation as it, you know, for anything, any reason. I need not say so in an open forum. But no, Supreme Court put that 50% limit. You cannot go beyond it. Thereby, you know, adhering to the equality principle, ensuring that the equality principle does not get distorted. Achha. Now we come to gender justice part. Gender justice part, there are two decisions. Briefly, I'll refer. One is NALSA versus Union of India. NALSA is National Legal Services Authority. Now there, again, Article 20, the concept of dignity was interpreted. Concept of dignity under Article 21 was held to include diversity in self-expression, which allowed a person to lead a dignified life. Now, why? What is the basis of this decision? Now, on the basis of this decision, the transgenders got a right. It was held that they have equal right as any other citizen of the country to claim fundamental rights. You cannot debar them. Article 14, Article 19, 19(1)(a), they're all in, they begin with the sentence, no person. It does not refer to citizens. So if a person is a transgender, he is a transgender, all right. You cannot discriminate him. You cannot debar him only because he is a transgender under the scheme of the Constitution. Then came the celebrated case of Navtej Singh Johar, where Section 377 of the Indian Penal Code was decriminalized to the extent that the relationship or the sexual intercourse between the adults is consensual. So the LGBTQ community, the lesbian, the gays and the bisexuals, transgenders, queer, they got, for the first time, a recognition from the highest court of the land. And the stigma that was attached to this community, to these people, was removed. So how, this brings in, different perception of the society. Then we come to gender equality. I'll just briefly touch. I will refer to 3 decisions on this. 3, actually 4 or 5 decisions are there, but I will very quickly run through them. Shahabano's case. In Shahabano, that was way back in 1985, it was held that once a divorced Muslim woman is paid meher during the iddat period. Meher is the amount agreed upon at the time of their marriage. After the period of iddat, she loses her right to claim any further maintenance. But no, the Supreme Court said, no, if the amount is not enough, she can claim maintenance under Section 125 of CRPC. Now, and most importantly, it was held that if there is a conflict between Muslim personal law and the CRPC would prevail. Now, Parliament sought to nullify this judgment by bringing in the Muslim Women's Protection of Rights in Divorce Act 1986. They said that no, meher and maintenance are to be paid to a divorced Muslim woman only during the period of iddat. Now, this was also challenged by a lawyer called Daniel Latifi. Supreme Court did not strike down the act, but held that the husband is bound to pay not only meher, but also a lump sum amount as would be reasonable and fair for her maintenance. You cannot throw 500 rupees by simply saying that, throw 500 rupees by saying that I have performed my duty of giving you maintenance. No, it must be reasonable and fair so as to ensure a decent living for that lady. Then followed Iqbal Banu's case. In Iqbal Banu's case, it was held that even if a petition is filed under 125, it should not be rejected on the technical ground that she has not approached the court, the provisions, has not made any claim under the Muslim Women's Act. Today, what has happened is, the final position is that a divorced Muslim woman can file a petition under Section 125 CRPC for recurring maintenance, or through the Muslim Women's Act, Protection of Muslim Women's Act, for a lump sum settlement. Now, this position, if you look at the Muslim society, look at the condition of the women as it existed prior to Shahabano and as it exists today, it's a great transformation. And it is through the Constitution that the Honorable Supreme Court has been able to bring in. Then just 2 decisions. One is Vishakha, as you all know. There in Rajasthan, a lady worker was gang raped. Then Vishakha is actually an NGO. brought the matter to the Supreme Court. This is a case of, some describe this case as a judicial, as judicial activism, because here the Supreme Court also legislated. It's a case of judicial legislation, but only to fill up legislative vacuum, because there was no law governing sexual harassment of women. So Supreme Court for the first time issued, guidelines. Those guidelines, in fact, have been lock, stock and barrel accepted and inserted in the new law, which was framed as a consequence. That is the Prevention of Sexual Harassment to Women in Workplaces Act. Whatever. Now, what was emphasized is that sexual harassment compromises the dignity of women and cannot be condoned. So these are decisions which are path breaking, and they're impactful. They impact a huge number of the large number of people. And what was there, imagine 50 years ago, and what is here today? We have internal complaints committee in every institution. It's mandatory. A case of sexual harassment cannot go unnoticed. It is all because of the Visakha decision. And the final decision is Sabarimala. Contentious issue, no doubt. But the Supreme Court ruled that women of all age older than 10 years or younger than 50 years can enter the shrine of Sabarimala without any gender discrimination. Now, this particular target group was debarred entry. But the Supreme Court said, no, you cannot, because this amounts to gender discrimination, which is foreign to the principles of the Constitution. So, friends, I have briefly touched upon, I've given examples, seeing is believing, as they say. And again, I will repeat, the proof of the pudding lies in its eating. So, I have tried to, while referring to these decisions, what I've tried to emphasize is that the Supreme Court has played a proactive role in safeguarding the rights of the people of this country as guaranteed under the Constitution of India. As I was referring to originally, the philosophy of this country, the cultural ethos, which is all reflected in this very valuable document, which I call the Bhagavad Gita for us, the Constitution. This philosophy is sought to be enforced, or whenever there is a wrong committed, it is sought to be remedied by the Constitution. And I do not say that we have achieved everything. Nobody can say that in a country like India, where it's as diverse as, and is in fact the most diverse country in the world. Every 50 kilometers, the language changes. But we have tried, we have made, I must say, sincere attempts, and we will continue to do so. This, gentlemen, ladies and gentlemen, is the history of the Constitution of India, Indian Republic, as also the history of the transformation that it has brought about in the society. So that's it. Thank you for inviting me and for bearing with me for so long. Thank you. God bless.
Thank you, sir, for your eroding speech, such a thought-provocative speech. Your Lordship was a member of our bar. He practiced in all branches of law. When he was selected to be appointed a district judge in the year 2009, he left the bar and joined in the bench. Therefore, he is having the experience of bar and bench both. Therefore, very nicely, he has touched every aspect of the topic. We, the members of Adhivakta Parishad, really very much enlightened because of your provocative speech. Thank you, sir. We will be inviting you in other webinars. Since we are doing it in regular intervals, we hope and trust that your Lordship will extend his helping hands, his cooperation to this type of webinar in future. Now, I would like to request our President, Adhivakta Parishad Odisha, Shri Kambupani Padhi, to deliver his presidential address. Over to you, Kambu.
ସମସ୍ତଙ୍କୁ ନମସ୍କାର। ସମ୍ମାନସ୍ପଦ ନ୍ୟାୟମୂର୍ତ୍ତି ଶ୍ରୀଯୁକ୍ତ ଶଶିକାନ୍ତ ମିଶ୍ର ମହୋଦୟ, ଆମ ଗହଣରେ ଉପସ୍ଥିତ ବରିଷ୍ଠ ଅଧିବକ୍ତା ଏବଂ ଆମ ସଂଗଠନର ସଦସ୍ୟ ଶ୍ରୀଯୁକ୍ତ ରୁଦ୍ର ପ୍ରସାଦ କର ମହୋଦୟ, ଶ୍ରୀଯୁକ୍ତ ଶୁଭ ବିକାଶ ପଣ୍ଡା ମହୋଦୟ ଏବଂ ଆମର କଟକ ଜିଲ୍ଲା ୟୁନିଟ୍ର ସଭାପତି ଶ୍ରୀଯୁକ୍ତ ବିମ୍ବିସାର ଦାସ ମହୋଦୟ ଏବଂ ଆମ ରାଜ୍ୟ ସମ୍ପାଦକ ମହୋଦୟ ଓ ଆମ ଗହଣରେ ଉପସ୍ଥିତ ସମସ୍ତ ବରିଷ୍ଠ ଅଧିବକ୍ତା ଓ ଅନ୍ୟ ଅଧିବକ୍ତା ଭାଇ ଭଉଣୀ ଏବଂ ଓଡ଼ିଶା ବାହାରେ ମଧ୍ୟ ଆମର ଏହି କାର୍ଯ୍ୟକ୍ରମକୁ ଆଭାସୀ ମାଧ୍ୟମରେ ଶୁଣୁଥିବା ଆମର ଅଧିବକ୍ତା ବନ୍ଧୁ ଏବଂ ନ୍ୟାୟ ବ୍ୟବସ୍ଥାରେ ସମ୍ମିଳିତ ଅନ୍ୟ ବ୍ୟକ୍ତି ମହୋଦୟ, ବର୍ତ୍ତମାନ ଆମେ ଅତି ସୁନ୍ଦର ଏବଂ ସାରଗର୍ଭକ ବିଷୟ ସବୁ ଶୁଣିବାର ସୁଯୋଗ ପାଇଲୁ ଏବଂ ଏଇ ଯେଉଁ ଆଜିକାର ଆମର ବିଚାର ବିଷୟ ଥିଲା, କିଛି ବିଷୟ ଭିତରୁ এই ବିଷୟକୁ ସମ୍ମାନସ୍ପଦ ନ୍ୟାୟମୂର୍ତ୍ତି ମହୋଦୟ ଆଗ୍ରହ ପ୍ରକାଶ କରିଥିଲେ, ତା ଉପରେ କିଛି ତାଙ୍କର ବିଷୟ ରଖିବେ, ଯାହା ଆମ ପାଇଁ ବହୁତ ଉପାଦେୟ ସାବ୍ୟସ୍ତ ହୋଇଛି ଏବଂ ଏତେ ସବୁ ବିଶଦ ବିଶ୍ଳେଷଣ ପରେ ମୁଁ ଭାବୁଛି ସେ ବିଷୟରେ ମୋର କିଛି ବିଶେଷ କିଛି କହିବାର ନାହିଁ। ତଥାପି ବ୍ୟବସ୍ଥା କାରଣରୁ ସଭାପତି ଭାବରେ କିଛି ବିଷୟ ମୋର ଉପସ୍ଥାପନ କରିବାର ଆବଶ୍ୟକତା ରହୁଛି। ଆମର जो विषय रहा कन्स्टिट्यूशनल हिस्ट्री ऑफ इंडियन रिपब्लिक एंड द आइडिया ऑफ ट्रांसफॉर्मेटिव कन्स्टिट्यूशन, यह एक प्रगतिशील समाज एवं एक समृद्ध गणराज्य पाई ए विचार सर्वदा न्याय व्यवस्था रे थिबा समस्त व्यक्ति पाखरे सजीव भाव रहिबा आवश्यक रहुछि। तत्संगे संगे जो माने ए राष्ट्र व्यवस्था चलाउछन्ति समानक मन रे मध्ये या ऊपर विस्तृत धारणा रहिबा आवश्यक एवं सही विषय को नहीं बोधे मान्यवर न्यायाधीश महोदय आज ए विषय रे समस्त को अवगत करने पाई आग्रह प्रकाश करथिले। आमे यदि भारतीय गणराज्यर कथा को विचार को नेबा, आजिकार व्यवस्था आमे आरंभ कलु जनवरी 26, 1950 रु, जहाँकि 72 वर्ष पर्यंत आमे से व्यवस्था चली आसुछु एवं अनेक समय समाजर आवश्यकता एवं व्यवस्था को सुचारू रूपे चलैया पाई विभिन्न समय विभिन्न परिवर्तन जहाँ उचित भाविचंती ताऊ करा हिछि। जदि आमे हमर भारतीय सामाजिक मूल्यबोध, राजनैतिक मूल्यबोध एवं न्यायिक व्यवस्था को देखिबा, स्वभावतः भारतीय समाज रे एक गणतंत्र प्रतिफलन आम पाई। जदि आम इतिहास पृष्ठा को जीवा, वैदिक जुगरे मध्य जनपद रे समस्ते मिसिकरी मिलित भाव में पदक्षेप नौथिले एवं समाज को ठीक भाव में परिचालना करुथिले। परे परे जेतेबेले राज्यर गठन हला, सेही समय राजनैतिक शासन पाई एक भौगोलिक क्षेत्र को राज्य कहगला, किंतु जो व्यवस्था चलुथिला शासन व्यवस्था, न्यायिक व्यवस्था, यू व्यवस्था थिला सर्वभारतीय स्तर में मूलतः तार वैचारिक दृष्टि तार गोटे आधार थिला। आमे जदि इतिहास को जीवा, एक विषय मु निश्चित भाव उपस्थापन करी। ହାରାହାରି ଖ୍ରୀଷ୍ଟପୂର୍ବ 4th ରୁ 6th ଶତାବ୍ଦୀ ସମୟରେ ଗ୍ରୀକ ଐତିହାସିକ ଡାଓଡୋରସ୍ ସେ ଭାରତକୁ ଆସିଥିଲେ ଏବଂ ଏହି ସମୟ ଆଲେକ୍ଜାଣ୍ଡରଙ୍କ ଭାରତ ଆଗମନର ହାରାହାରି 200 ବର୍ଷ ପରର ବିଷୟ ସେ ବର୍ଣ୍ଣନା କରିଥିଲେ ଏବଂ ତାଙ୍କର ଯେଉଁ ଉଦ୍ଧୃତ କରିଥିଲେ ଲେଖାରେ ସେଥିରେ ଭାରତରେ ଗଣରାଜ୍ୟ ଏବଂ ଲୋକତନ୍ତ୍ରର ବ୍ୟବସ୍ଥା ବାବଦରେ ସେ ବିସ୍ତୃତ ଭାବରେ ଉପସ୍ଥାପନ କରିଛନ୍ତି। ଇତିହାସରୁ ଏହା ମଧ୍ୟ ଜଣାପଡ଼େ ଯେ ଭାରତରେ ତତ୍କାଳୀନ ସମୟରେ 16ଟି ବଡ଼ ବଡ଼ ଗଣରାଜ୍ୟ ଥିଲା ଏବଂ ତାଙ୍କ ମଧ୍ୟରୁ ଶାକ୍ୟ ଗଣରାଜ୍ୟ, କଳିୟାସ ଗଣରାଜ୍ୟ, ମାଲ୍ୟ ଗଣରାଜ୍ୟ, ଲଚ୍ଛବୀ ଗଣରାଜ୍ୟ ଏସବୁ ପ୍ରମୁଖ ଗଣରାଜ୍ୟ ଥିଲା ଏବଂ ତାଙ୍କର ଗଣତାନ୍ତ୍ରିକ ଶାସନ ବ୍ୟବସ୍ଥା ବହୁତ ସୁଦୃଢ଼ ଥିଲା। ଯଦି ଆମେ ଦେଖିବା ଲଚ୍ଛବୀ ଗଣରାଜ୍ୟରେ ହାରାହାରି ଯାହା ସେ ଉଦ୍ଧୃତ କରିଛନ୍ତି 7077 ପ୍ରତିନିଧିକୁ ନେଇକରି ସେମାନେ ଶାସନ ବ୍ୟବସ୍ଥା ଚଳାଉଥିଲେ ଏବଂ ତାଙ୍କର ଯେଉଁ ରାଜକୀୟ ଶାସନ ସଂସ୍ଥା ମଧ୍ୟ ପ୍ରତିଷ୍ଠିତ ହେଇଥିଲା ଏବଂ ସେମାନେ ଯାହା ନିର୍ଣ୍ଣୟ ନେଉଥିଲେ ରାଜା ତାକୁ ପାଳନ କରିବାର ଉତ୍ତରଦାୟିତ୍ୱ ରାଜାଙ୍କ ଉପରେ ରହୁଥିଲା ଏବଂ ଏହିପରି ଭାବରେ ଏକ ପ୍ରାରମ୍ଭିକ ଗଣତନ୍ତ୍ରର ବ୍ୟବସ୍ଥା ଆମେ ଆମର ଭାରତୀୟ ଶାସନ ବ୍ୟବସ୍ଥାରେ ଆମେ ଦେଖିପାରିବା। ତାପରେ ମାଲ୍ୟମାନେ ଯେଉଁ ଶାସନ କରୁଥିଲେ ଏବଂ ତାଙ୍କର ମୁଖ୍ୟ ଆସେମ୍ବଲି ଯାହାକୁ ଆମେ କହୁଛୁ ଏବଂ କିମ୍ବା ଗଭର୍ଣ୍ଣିଂ ବଡି ଯେଉଁ ଥିଲା ତାହା କୁଶୀନଗରରେ ସେମାନେ ସ୍ଥାପନ କରିଥିଲେ। ତ ଏହି ପ୍ରକାର ଯଦି ଗୁପ୍ତ କାଳକୁ ଆସିବା, ଗୁପ୍ତ କାଳରେ ଯଦି ଚନ୍ଦ୍ରଗୁପ୍ତ ମୌର୍ଯ୍ୟ ରାଜା ଥିଲେ କିମ୍ବା ଅଶୋକ ସମ୍ରାଟ ଥିଲେ ତଥାପି ତାଙ୍କ ଶାସନ ବ୍ୟବସ୍ଥା 4 ସ୍ତରର ନ୍ୟାୟ ବ୍ୟବସ୍ଥା ଥିଲା ଏବଂ ଶାସନ ବ୍ୟବସ୍ଥା ମଧ୍ୟ 3 ସ୍ତରରେ ଶାସନ ବ୍ୟବସ୍ଥା ଥିଲା ଏବଂ ସର୍ବଶେଷରେ ରାଜାଙ୍କର ପାଖରେ ଶେଷ ନିଷ୍ପତ୍ତି ରହୁଥିଲା ଏବଂ ରାଜାଙ୍କୁ ଏବଂ ସମ୍ରାଟକୁ ସେ ନିଷ୍ପତ୍ତିରେ ସହଯୋଗ କରିବା ପାଇଁ 16ରୁ କିମ୍ବା 16ରୁ ଅଧିକ ବିଭିନ୍ନ ରାଜ୍ୟର ପ୍ରତିନିଧି ରହୁଥିଲେ ଏବଂ ସେହି ସମୟରେ ରାଜାଙ୍କର ପାଖରେ ତାଙ୍କର ପ୍ରତିନିଧି ମାନଙ୍କ ପାଖରେ ନିର୍ଣ୍ଣୟ ନେବାର ଅଧିକାର ଥିଲା ଯେ ରାଜ୍ୟର ଶାସନ ବ୍ୟବସ୍ଥା, ଶାସନ ପ୍ରଣାଳୀ, ପ୍ରଶାସନ, ନ୍ୟାୟ ପ୍ରଣାଳୀ ଏବଂ ପ୍ରତିରକ୍ଷା ପରିଚାଳନା ଏସବୁର ସେମାନେ ସାମୂହିକ ନିର୍ଣ୍ଣୟ ନେଉଥିଲେ ଏବଂ ତାକୁ କାର୍ଯ୍ୟକାରୀ କରିବାର ଉତ୍ତରଦାୟିତ୍ୱ ରାଜା ଏବଂ ସମ୍ରାଟଙ୍କ ପାଖରେ ଥିଲା। ଏସବୁ ଯଦି ଆମେ ଗଭୀର ଅନୁଧ୍ୟାନ କରିବା ଶାସନ ବ୍ୟବସ୍ଥାର ବର୍ତ୍ତମାନ ଲିପିବଦ୍ଧ ଯେଉଁ ଆମ ପାଖରେ ଉପଲବ୍ଧ ଅଛି, ପୁସ୍ତକ ଉପଲବ୍ଧ ଅଛି, ତାହା ହେଉଛି ଚାଣକ୍ୟଙ୍କର ଅର୍ଥଶାସ୍ତ୍ର ଏବଂ ଏ ଅର୍ଥଶାସ୍ତ୍ରରେ ମଧ୍ୟ ଆମେ ରିପ୍ରେଜେଣ୍ଟେଟିଭ ଆଡମିନିଷ୍ଟ୍ରେଟିଭ ସିଷ୍ଟମ ପ୍ରତିନିଧିମୂଳକ ଶାସନ ବ୍ୟବସ୍ଥାର ଆଲେଖ୍ୟ ଆମେ ପାଇପାରିବା ଏବଂ ତାକୁ କୌଟଲ୍ୟ ତାଙ୍କର ଅର୍ଥଶାସ୍ତ୍ରରେ ସର୍ବୋତ୍କୃଷ୍ଟ ଏବଂ ବିବାଦ ଶୂନ୍ୟ ଏବଂ ଏକ ବିସ୍ତୃତ ଶାସନ ବ୍ୟବସ୍ଥା ଭାବରେ ତାକୁ ସେ ବର୍ଣ୍ଣନା କରିଛନ୍ତି। ତାପରେ ବିଭିନ୍ନ ସମୟରେ ମଧ୍ୟ ସେଇ ପ୍ରକାର ରାଜା ଯେତେବେଳେ ଶାସନ କରୁଥିଲେ ସେ ଜନପ୍ରତିନିଧି ମାନଙ୍କୁ ନେଇକରି ତାଙ୍କ ରାଜ୍ୟସଭା ଗଠନ କରୁଥିଲେ ଏବଂ ଜନପ୍ରତିନିଧି ମାନଙ୍କର ମତାମତକୁ ନେଇକରି ହିଁ ଶାସନ ବ୍ୟବସ୍ଥା ଚାଲୁଥିଲା। ଯଦିଓ ତାର କିଛି ବ୍ୟତିକ୍ରମ ଆମେ ଦେଖିପାରିବା କିନ୍ତୁ ମୋଟାମୋଟି ଭାବରେ ଭାରତର ଶାସନ ବ୍ୟବସ୍ଥାକୁ ଯଦି ଆମେ ଦେଖିବା, ଇତିହାସକୁ ଦେଖିବା, ଏସବୁ ବିଷୟକୁ ଆମେ ସର୍ବାଗ୍ରେ ଜାଣିପାରିବା। ତାପରେ ବିଭିନ୍ନ ସମୟରେ ଆମେ ଅନ୍ୟ ଆକ୍ରାନ୍ତ ମାନଙ୍କର କବଳି ଥିଲୁ ଏବଂ ଆମର ଶାସନ ବ୍ୟବସ୍ଥା ମଧ୍ୟ ସେଥିରେ କବଳି ଥିଲା। କିନ୍ତୁ ପରବର୍ତ୍ତୀ ସମୟରେ ଆମେ ଯେତେବେଳେ ସ୍ୱତନ୍ତ୍ରକୁ ଆସିଲୁ ସେତେବେଳେ ସ୍ୱତନ୍ତ୍ର ପାଇଁ ମଧ୍ୟ ଆମର ବହୁତ ବଡ଼ ଜନ ଆନ୍ଦୋଳନ ଚାଲିଲା। ବହୁତ ଅସଂଖ୍ୟ ଲୋକଙ୍କର, ମହାମନୀଷୀଙ୍କର, ସାଧାରଣ ଲୋକଙ୍କର ତ୍ୟାଗ ତପସ୍ୟା ବଳରେ ଆମେ ସ୍ୱତନ୍ତ୍ରକୁ ଆସିଲୁ ଏବଂ ସେହି ସମୟରେ ଯେତେବେଳେ ତତ୍କାଳୀନ ଚିନ୍ତାନାୟକ, ରାଷ୍ଟ୍ରନାୟକ ସେମାନେ ସମସ୍ତେ ବସିକିରି ଦେଶର ଶାସନ ବ୍ୟବସ୍ଥା ଚଳାଇବା ପାଇଁ ତାଙ୍କର କନଷ୍ଟିଟ୍ୟୁସନ ତିଆରି କରିବା ଆରମ୍ଭ କଲେ, ପ୍ରକ୍ରିୟା ଆରମ୍ଭ କଲେ, ଶେଷରେ ବିଚାର ଆସିଲା ଯେ ଆମେ ତ ସମ୍ବିଧାନ ତିଆରି କଲୁ, ସମ୍ବିଧାନକୁ କିପରି ଭାବରେ ଲିପିବଦ୍ଧ କରିବା। ତ ଲିପିବଦ୍ଧ କରାଗଲା ଏବଂ ଏ ବିଷୟ ନିଶ୍ଚିତ ଭାବରେ ଆମେ ସମସ୍ତେ ଜାଣିବା ଏବଂ ବୁଝିବା ଆବଶ୍ୟକ ଯେ ସେଥିରେ ପଶ୍ଚିମବଙ୍ଗର ନନ୍ଦଲାଲ ବୋଷ से समय विशिष्ट चित्रकलार शिल्पी थिले से तांको डका हेतिला एवं से तांकर स्वहस्तरे मूल संविधान जोटा हाथ लेखा संविधान एवं समस्त कॉन्स्टिट्यूशन असेंबली सब सदस्य दस्तखत रही से किसी चित्र को मध्य स्थान दिखाई मु विषय उपस्थापन करिवार तात्पर्य यह जे आमर संविधान रे भावनाटा कौन थिला जो संविधान तैयारी कराला से मूल भावनार प्रतिफलन से चित्र माध्यम आम पाइपर जहाँ लेखाई ताकू तो आम व्यवस्था कार्यकारी करूछु न्यायिक व्यवस्था कार्यकारी करूछु एवं शासन व्यवस्था ताकू पालन करूछु किंतु जो संदर्भ रे एवं जो पृष्ठभूमि रे संविधान रो विभिन्न धारा दिया गला ताकू सांकेतिक भाव रे से चित्र सब दर्शा होइछि से मुख्यतः वेद समय वैदिक लाइफ जोटा थिला वेद समय आमर जो जीवन व्यवस्था थिला तार एक चित्र कराई एवं ताकू सिटीजन चैप्टर जोटा आमर संविधान रे से अंकित कराई एवं सही परी फंडामेंटल राइट्स मौलिक अधिकार जो चैप्टर अच्छी से चैप्टर रे भगवान राम लक्ष्मण एवं सीता सहित लंका विजय पर अयोध्या आगमन करुले ताकू स्थानित कराई एवं डायरेक्टिव प्रिंसिपल ऑफ स्टेट पॉलिसी से चैप्टर रे भगवत गीता रे भगवान श्रीकृष्ण अर्जुन को उपदेश दौथवा चित्र अंकित कराई एथिरे आम निश्चित भाव में बुझी पारिबा जे गीतार मूल गीतारे तो बहुत तार विषय अच्छी किंतु गोटे मूल विषय अच्छी कर्तव्य पालन बिना फल प्राप्तिर आशा नहीं करी कर्तव्य पालन तो ये सब जो विभिन्न चैप्टर गुड़ाक विभिन्न फोटो चित्र अंकित कराई एक भावनात्मक एवं एक सांकेतिक संदेश आम समस्त को दौची से हीपरी भगवान नटराज शिवंकर फोटो अंकित कराई जो चैप्टर रे फाइनेंस प्रॉपर्टी रिलेटेड मैटर कंट्राक्ट सूट्स ये सब विषय गुड़ाक अच्छे ये सब व्यावहारिक विषय गुड़ाक एवं विभिन्न वस्तु प्राप्तिर को लेकर जहाँ द्वंद्व रही से द्वंद्व को किमिति समाधान करिहो से सब विषय एवं विभिन्न भारतीय सांस्कृतिक परंपरा भारतर ऐतिह्य एवं भारतर सांस्कृतिक वैभव एवं जीवन शैली को प्रतिफलित करुथिबा एवं समृद्ध करिथिबा अनेक संत पुरुषंकर संत कबीर कहिबा गौतम बुद्ध कहिबा स्वामी विवेकानंद कहिबा एवं किसी अकबरंकर मध्य फोटो दिया किंतु बहुत लोकंकर फोटो नहीं से भीतर औरंगजेबर मध्य फोटो चित्र दिया है आम बुझुवा कहीं दिया है तो ये सब जिते मूल भावना को लेकर संविधान लिखागला तत्कालीन समय सामाजिक व्यवस्था राजनीतिक व्यवस्था ये सब को से बुझी एवं आगामी समय कि प्रकार परिस्थिति आसी पारे ताकू मन रे रखिक विभिन्न विधि निर्णय करागला तो आम जो विषयटा आज चर्चा करूँ ये तो संविधान है संविधान उपरे आमर शासन व्यवस्था आरंभ है न्यायपालिका तार कार्य करि चलले किंतु पृथ्वीर सबुथुरु बेसी संख्या रे जदि अमेंडमेंट कराई ताहले आमर भारतीय संविधान को कराई एवं यह स्वाभाविक जदि आम भारत वर्ष को बुझुचु भारतर विविधता को आम हृदयंगम करूछु एवं समस्तंकर विभिन्न भौगोलिक क्षेत्र में विभिन्न प्रकार जीवन शैली विभिन्न प्रकार सामाजिक व्यवस्था एवं जीवन जीवा पाई जो प्रकार संघर्ष करने को पड़ी थाए एवं भाषार व्यवस्था शिक्षार व्यवस्था स्वास्थ्यगत व्यवस्था से भौगोलिक व्यवस्था को नहीं करी विभिन्न समय विभिन्न प्रकार विभिन्न जगह आम देखा पाऊ ताकू ठीक भाव ପରିଚାଳିତ କରିବା ପାଇଁ ଏବଂ ତାକୁ ତାର ଲୋକଙ୍କର ଆବଶ୍ୟକତାକୁ ସମାଧାନ କରିବା ପାଇଁ ଏସବୁ ପରିବର୍ତ୍ତନର ମଧ୍ୟ ଆବଶ୍ୟକତା ବହୁତ ସମୟରେ ଅନୁଭବ କରାଗଲା ଏବଂ ସେଥିପାଇଁ ଏତେ ସବୁ ଆମେଣ୍ଡମେଣ୍ଟ ବି ଆସିଛି। ତ ଏ କଥା ମନରେ ଆସେ ଯାହା ମାନ୍ୟ ନ୍ୟାୟମୂର୍ତ୍ତି କହିଲେ ଯେ ଆମେ ତାକୁ ଟ୍ରାନ୍ସଫର୍ମେଟିଭ ଇଟ୍ ଇଜ୍ ଆଇଡିଆ ଅଫ୍ ଟ୍ରାନ୍ସଫର୍ମେଟିଭ କନଷ୍ଟିଟ୍ୟୁସନ କହିପାରିବା କି? ଆମର ଏଇ ଯୋଉ ବିଚାରକୁ ଏହା ଚରିତାର୍ଥ କରୁଛି ନା କିଛି ଆବଶ୍ୟକତା ନେଇକରି କିଛି ଖାଲି ପରିବର୍ତ୍ତନ କରାଗଲା? ଆମେ 75 ବର୍ଷର ସ୍ୱାଧୀନତା ଏବଂ 72 ବର୍ଷର ସାମ୍ବିଧାନିକ ବ୍ୟବସ୍ଥା ମଧ୍ୟରେ ରହିକରି ସମ୍ବିଧାନ ଯେଉଁ ଅଧିକାର ଦେଇଛି ଆମର ଶାସନ ବ୍ୟବସ୍ଥା ଏବଂ ନ୍ୟାୟ ବ୍ୟବସ୍ଥା ଆମେ କ'ଣ ସମାଜର ଶେଷ ଧାଡ଼ିରେ ଥିବା ଲୋକ ପାଖକୁ ପହଞ୍ଚି ପାରିଛୁ? ସମ୍ବିଧାନର ବିଷୟକୁ କ'ଣ ସେଇ ଲୋକ ଜାଣିପାରୁଛି? ସମ୍ବିଧାନ କ'ଣ ସେ ବୁଝିଛି? ଶାସନ ବ୍ୟବସ୍ଥାକୁ ସେ ହୃଦୟଙ୍ଗମ କରିପାରିଛି? ଏବଂ ତା ପାଇଁ ବ୍ୟବସ୍ଥାରେ କ'ଣ ଅଛି? ତାର ଅପେକ୍ଷା କ'ଣ ରହିବା କଥା? ଆମେ ଯଦି ସମୀକ୍ଷା କରିବା ତାହେଲେ ବର୍ତ୍ତମାନ ବି ତା ପାଖରେ ଏସବୁ କଥା ପହଞ୍ଚି ନାହିଁ। ସେଥିପାଇଁ ଆମର ଲିଗାଲ ଫ୍ରେଟର୍ନିଟି ଏବଂ ମୁଖ୍ୟତଃ ମୁଁ କହିବି ଯେଉଁମାନେ ଭାରତୀୟ ବ୍ୟବସ୍ଥାକୁ ଏବଂ ରାଷ୍ଟ୍ରକୁ ନିଜର ଭାବୁଛନ୍ତି ଏବଂ ରାଷ୍ଟ୍ର ପାଇଁ ସମର୍ପିତ ଅଛନ୍ତି ଏବଂ ଏକ ପରମ ପ୍ରଭାବଶାଳୀ ରାଷ୍ଟ୍ର ନିର୍ମାଣ ପାଇଁ ସ୍ୱପ୍ନ ଦେଖୁଛନ୍ତି, ସେହି ପ୍ରକାର ବ୍ୟକ୍ତିଙ୍କ ପାଇଁ ବହୁତ ବଡ଼ ଉତ୍ତରଦାୟିତ୍ୱ ଆଜି ଅଛି ଯେ ଏହି କାର୍ଯ୍ୟକୁ ଆମେ ତ୍ୱରାନ୍ୱିତ କରିବା ଏବଂ ବ୍ୟବସ୍ଥିତ ଢଙ୍ଗରେ ସାଂଗଠନିକ ବ୍ୟବସ୍ଥା ଭିତରେ ଆମେ ସେ ଲୋକଙ୍କ ପାଖକୁ ପହଞ୍ଚିବା। ଏବଂ ଏ ଦେଶ କ'ଣ, ଏ ଦେଶର ବ୍ୟବସ୍ଥା କ'ଣ, ତାର ଅଧିକାର କ'ଣ, ନ୍ୟାୟ ପ୍ରଣାଳୀରେ ସେ କ'ଣ ପାଇପାରିବ, ପ୍ରଶାସନିକ ବ୍ୟବସ୍ଥାରେ ତାର ଜୀବନକୁ ଠିକ କରିବା ପାଇଁ ଶିକ୍ଷା, ସ୍ୱାସ୍ଥ୍ୟ ଏବଂ ଏକ ସ୍ୱାଭାବିକ ଜୀବନଯାପନ କରିବା ପାଇଁ କ'ଣ ଆମେ କରିପାରିବା ଏବଂ ସେ କିପରି ତାର ଲାଭ ପାଇପାରିବ, ଏସବୁ ବିଷୟକୁ ଆମେ ନିଶ୍ଚିତ ଭାବରେ ଚିନ୍ତନ କରିବା ଆବଶ୍ୟକ। ଏବଂ ଏହା ଉପରେ ଆମର ବହୁତ ସଂଗଠନ କାମ ଚାଲୁଛି ଏବଂ ଆଗାମୀ ସମୟରେ ମଧ୍ୟ ବହୁତ କିଛି ଆଗକୁ ଆମର କାର୍ଯ୍ୟକ୍ରମ ରହିବ। ଆଜି ବିଷୟକୁ ନେଇକରି କେବଳ ଏତିକି ମୋର ବକ୍ତବ୍ୟ ଅଛି। ମୋର ବକ୍ତବ୍ୟ ବିରାମ ଦେଉଛି। ଭାରତ ମାତା କି ଜୟ।
Possibly.
Today, actually, we are facing a lot of difficulties in connectivity. Therefore, actually, I was not the person who was given responsibility to introduce the guests. However, since the network problem, our brother, Subha Panda, could not join. While giving introduction, I have forgotten that today we are having with us Sri Bimbishar Das, President of Cuttack Unit Adhivakta Parishad. He's a renowned lawyer, and today in this function, I would like to request him to offer vote of thanks to our distinguished guests.
Thank you, Jano, my younger brother. Actually, proposing vote of thanks is considered to be customary in character. But I think I am fortunate enough to grab this opportunity to propose the vote of thanks to our esteemed chief guest, Justice Sashikanta Mishra. I must say, worthy son of a worthy father. I knew about Justice Sashikanta Mishra for the last about 27 years when his lordship was in practice. For his pleasing behavior, smiling face, and accessible to all junior advocates, he was having that identity in the, I must say. even before his lordship's elevation about 1 or 2 years back, I had an interaction with him. So I just cannot forget those days. Now I didn't know many things. I didn't know what I say, because his lordship's in-depth knowledge about law, there is no question about that. But for the last two meetings I attended, where Justice Mishra deliberated on certain topics. One is in the death anniversary of Prafulla Dhal, our senior advocate. There, his lordship Justice Mishra deliberated, and it was a eye opener for all juniors, not only juniors. Even if somebody wants to learn, he can learn at the last day also. So, from his talk that day and today's talk, I must say, he is not only a judge, he is a thinker, he is a voracious reader, first of all. Unless somebody reads, possibly, I'm thinking, he cannot go to the in-depth thinking of the judgments. Particularly, Article 16.4a, your lordship was saying about Indra Sanai, thereafter M. Nagaraj, thereafter Zonal Singh. Zonal Singh, your lordship, on 3rd of this month, another judgment has come. Means after Zonal Singh, Karnataka government, what they did, for the purpose of getting quantitative data in respect of representation, inadequate representation, they made some groups. And now Supreme Court has said, no, you cannot make groups. You must have to go to cadre, because cadre has been recognized. Indra Sanai is also M. Nagaraj. I am at one with our state secretary that if your lordship agrees, then we can have different webinars on different legal topics that will enhance everybody knowledge, and it will be very much beneficial for the junior. So I take this opportunity to request your lordship for that. And I am short of words. I cannot, I don't find words to express my thanks for Justice Mishra. But however, it is my pleasurable experience. Now, coming to Rudra Prasad Karo, my senior, who was the moderator, I find an Ajat Satru in him in High Court Bar. He doesn't have any Satru. He's having a smiling face, and a topic is given to him, he comes prepared. In courts also, I find always him coming to the courts in preparedness. He's such a eloquent speaker. He is also having a smiling face always, and greatest qualities of him, he takes everything positively. That's what I have learned from him. I'm thankful to him for his moderation on today's topic. Now, coming to Kambupani, he is our state president. Kambupani narrated many things from our social character, and about equivalence of our constitutional provision in our social character, in our history. So we are benefited with the talks of Kambupani also. It is customary in character, otherwise he is our president. He is our president. I get this opportunity to thanking him. With these words, I must thank also Gyanalok Mahanti, State Secretary, and he couldn't join Pintu Subha Bikash Panda. They were also very much. They are always helpful to have these type of webinars. Actually, as a matter of fact, this is about the 6th or 7th webinar we have. Very recently, we had some other webinars also. So looking forward to days ahead with Justice Mishra's cooperation for having some other webinars on legal topics. I conclude. Over to
Thank
President.
you.
Yes.
Thank you, Mr. Bhai.